I beg to mention item number 5, madam.
Item number 5.
5, madam. Similar, with a similar prayers, madam, repetitions pending for the Honorable Supreme Court, madam. That matter has been pending for some time, madam. Almost identical prayers are there, madam, in the Supreme Court side.
Yes, SLP is pending. That is in relation to that CA matter or what?
It's related to Aadhaars not being provided, madam.
And concept of the petitioner has submitted that identical controversy is pending before the Honorable Supreme Court. This PIL petition along with the writ petition or list these matters after 10 weeks.
Lordship.
May I please? I'm in item number 6, which is taken up together.
Yeah.
So the petition number 1 and item number 6 has died on 22/4/2024. Petition number 1 expired. So his name may be struck off.
You want to get the name of that petitioner number 1 struck off?
Yes, my lords.
Before that, pending before when counsel appearing in the writ petition number 1411/2022 is informed that since the petitioner number 1 has died, he made has made a oral request that since the petitioner number 1 has expired, his name may be deleted from the array of the respondents. The request is accepted. The name of the petitioner 1 is deleted from the array of the petitioners. Amended cause title be filed within a period of 1 week. List these matters after 10 weeks.
May I please, your lordship, with due consent from the other side, lordship, I beg to mention for item number 7, lordship, Nagaon DC office, lordship, pension paper has been sent to the AG, lordship, but due to some inadvertent mistake, lordship, some documents yet to receive by them, lordship, so I need some more time, lordship, to complete the process. Item 7.
What documents you want?
Lordship, as per their letter, lordship, this letter, lordship, pension service book we have uploaded in digital portal, lordship. Service book is yet to upload.
It's a plain and simple that he was
Lordship,
appointed as Sridhar and thereafter his services were removed as per the court's order. Now he is seeking pensionary benefit for that post, which has been cancelled.
Short time, lordship.
So what time?
They are trying to give him for revenue service for when purposely the revenue service they claim the wrong interpretation. They are holding that.
You are intended to give grant benefit to it.
Lordship.
Why? How?
Lordship, as per final notification, lordship, which has been
The notification, his appointment on the post of Shrestri, Revenue Shrestri, cancelled by this court. Now,
lordship, due to election, lordship, there are some.
that's the judgment of the learned single judge is in your favor, and despite that, if you are intended to, it's okay. Yes.
One step.
Lordship, my lord, item 13(1)(3).
1-3.
Yes, this matter has become infractions because the tenure was up to 31st March 2024.
And concept of the petition is submitted that this writ petition has become infectious by a flux of time. Dismissed as infructuous.
Lordship, I am appearing for the transport department. If you are blessed.
Please, your lordship. That's what I beg to mention. Item number 28, your lordship. My senior is suffering from a fever and severe headache, your lordship. He did not attend the court today. So I'll accommodation of today's thing.
Item number 28. Yes,
Eviction matter, there was a consent. Now they please bring me into order.
Same ground on the last date.
Lordship, he is not well, your lordship. That is why.
In fact,
Anything, your lordship, anything.
the Board of Revenue, without going into the procedure that these notices have not been, notices issued to the dead person, has not at all been served without giving any opportunity, only on the basis of the.
Single test paper, then they have come back.
On account of illness of some sort, urgent. Yes,
May I please your lordship? Lordship, I beg to mention for listing of a writ appeal lordship on 28th of May lordship. Lordship,
by specific date,
no, not lordship. If not inconvenient, your lordship, otherwise lordship, after the judgment passed by the honorable lordship, several recreation.
grant permission grant.
Lordship, deeply obliged lordship.
May I please, your lordship? Lordship, I beg to mention for listing of a read appeal, it is 2021 matter. Kindly may allow on next week.
Next week.
Obliged.
May I please your lordship, my lord? I may be excused, my lord, in respect to item number 54. Due to some, my lord, shifting of the chamber, my lord, brief is misplaced, my lord, so I could not locate the brief. Kindly give me 1 week's time, my lord.
File is missing.
I'm missing the misplaced.
I'm from the respondent, man.
Take the file from him.
No, Lord, it is a voluminous record, my lord. I need to prepare the case, man. Because department proceeding, then CAT, then my lord, read petition.
On account of section.
The areas have a policy of the of the situation. There is a close to print.
Urgent.
My lord.
Please, your lordship. I beg to mention item number 32 and 33, lordship. I have already engaged senior counsel, lordship, but is not ready to argue today, lordship. So
What's main in these matters? Your term has already expired. How can you continue in this item number 32? How can you continue your term as Gam Mukhya? Has already been expired. Where is the question of urgent?
lordship, only for the day, lordship.
For what? There's nothing in this matter, sir.
Last opportunity, my lord.
Monday lagao. And on that day, we will not grant the adjournment. You prepare the matter and argue it out.
Okay.
In this ground that senior is not able, not going to adjourn the matter.
Next week, lordship. Next.
Monday. Yes.
May I please, lordship? Lordship, I beg to mention item number 29.
29.
My senior Mr. Vicina is absent today due to annual leave. Matter may be adjourned for the day only, lordship.
Item number 20.
My lord, in item number 29, I am appearing for the lordship respondent.
29.
Yes, lordship.
That has already been adjourned. Some has made a mention.
28,
Huh?
28 is it?
No, lordship.
That was 28 in Monday, on Monday only.
Lordship, last two occasion, lordship, they have adjourned, took time without informing us.
Monday will
lordship.
not grant the adjournment. Monday.
Lordship,
Obliged.
Monday.
Yeah.
May please your right. Lordship, Monday, lordship, we have 20, 21, lordship. Tuesday, lordship.
Tuesday. Yes, Tuesday.
May please your lordship, I beg to mention item number 31. My senior is not well, lordship, so it will be taken after a week, lordship.
Compassion upon.
2015, your father died, your mother's application rejected, not challenge that order. Now, after attaining majority, what's the point in this?
I think since 3 days back, he is suffering from illness, lordship, lying on bed, so.
Day after tomorrow.
May I please, your lordship? Lordship, in item number 43, we have filed an additional affidavit on Friday. That may be called for, lordship.
43
Lordship.
is it?
Yeah.
On behalf of the government,
Yes, lordship.
Okay.
All right, sir.
all for that.
May I please, lordship? I'm praying for adjournment because my senior is out of town.
Which matter?
Item number 53.
53 hearing matter.
Yes, lordship.
कुछ नहीं है सर, तो हो गया सर, कह भी अगर बोलते हैं तो डिस्प्यूट है सर।
Nothing in these matters. In fact, you are lingering on without taking any merit in
I
the matter.
apologize, Your Lordship.
Tuesday.
All right. Much obliged.
It please your lordship, I beg to mention item number 42. I'm for the respondent number 4, Mr. R.B. Hukan and R. Sharma could not be present due to some personal reasons. If you could kindly adjourn the matter to the
Time of
fix.
the last occasion for filing affidavit to the reply counter, affidavit to counter the reply.
So due to some personal reasons, they couldn't be present. You could
Adjourn.
fix it after 2 weeks.
Yes.
Obliged.
May it please the Lordship. Lordship, I beg to mention an item for listing. It was filed on 18th April, but since then it has not been listed.
Next week, Lagal.
May I please the Lordship? Lordship, I beg to mention for listing of the matter by tomorrow, Your Lordship. But
Why?
it is,
The agency?
Your Lordship, it is a PIL challenging the notification which bars the transfer of property among different, among various communities, religious communities, Your Lordship.
So when the notification was issued,
It is issued in 7/3/2024, Your Lordship.
7/3 to 2024, so
Yes,
what is
sir.
the urgency of tomorrow?
Your Lordship, people are suffering, Your Lordship.
People are suffering since 7th of March. So what is the urgency of tomorrow? June first week.
Okay, Your Lordship.
Maybe Your Lordship. I beg to mention item number 51, my lord. Mr. R.K. Dapsuri is out of station in another court, my lord. That matter may be taken up after adjourn for the day, my lord.
Adjourn.
No? 51.
Yes.
And my lord, 52, my lord, same prayer. my lord.
Adjourn.
I have taken consent also.
They are not willing to do what to.
Nothing is there.
And from the next week, please mind it, we are not going to adjourn on the
Yes,
asking, please. Try
Yes,
to understand, you have taken consent from the other side and get the order, with the consent of the other side also. Write the order, we'll sign it.
My lord, next time I'll. in it.
Sir, I mean, they don't even circulate a thing. We have a system here. We give a notice, that also is.
Daily list for orders item 1.
In this case, your lordship, so far as the grievance of the petitioner is concerned, your lordship, that has already been taken care of, your lordship.
So
He has
what about that, they have taken some action against that
Yes,
contractor?
that taken, but subsequently this honorable court was pleased to expand the scope of the PIL, your lordship, and such certain instructions from the authority.
Yes.
So far as my grievance is.
My lord, as regards his grievance, my lord, he has stated and that period is also over. And as regards other, my lord, we are looking into it, my lord, it is an expanded whole of Assam. My lord, the directions were passed, there was a committee formed. My lord, the office, due to this, my lord, if lordship directs us to for updated, it should be listed after some few weeks, my lord. Otherwise, my lord, the PIL,
Whatever it may be, if the court has expanded this scope of the PIL, then you should refer it to the.
it's a memo task, my lord, so it needs some more time, my lord.
For us, I may seek an adjournment to examine the court's frame comprehensive scheme. Have you framed any scheme or guideline?
Well, there are already guidelines in place. This person has flouted. There are already we have rules, my lord. So the person has to extract minerals only in the compliance of a mining plan. In some cases, there are some deviations, my lord. It's a totally mammoth task, my lord. We need some more time, lordship directs. So otherwise, my lord, the PIL is the
That's
settlement
right.
period also over, my lord.
Since the scope is expanded, so we have to comply with the direction.
Yes, my lord. It was our own officer, my lord, who came and said all this, my lord. My lord, will need some more time, my lord.
Look here. This writ petition is filed by the PIL, essentially raising a grievance that the contractor to whom the contract was granted to collect stone, sand and gravel from Gowata Sand and General Mahal Krishna Narzari is indulged in illegal mining out of the scope of the contract granted to him. Full stop. Learned concept for the petitioner has submitted that so far as regarding his grievance regarding the particular contractor is concerned, the same has already been resolved. And his contract period is also over. However, it is noticed that this court expanding the scope of the PIL petition issued certain direction to the Forest and Environment Department, Government of Assam, to frame a comprehensive scheme and guideline regarding the riverbed mining. Full stop. Learned concept of the Forest and Environment Department has submitted that the guideline is already in place. However, a status report regarding the implementation of the said guideline has to be filed. In place, 2 weeks time, 3 weeks time for that.
But some more, my lord. We have 27 divisions, my lord. Only 6 divisions have submitted report.
4 weeks.
My lord,
4
4 weeks.
weeks time for that.
Obliged.
Item 2 and 3.
You are supposed to file an affidavit.
Lordship, the instructions I have received, Lordship.
What do you mean by instructions? You file an affidavit.
Lordship, I will, Lordship.
And supply a copy to the opposite party.
Yes.
Lordship, I will.
Okay. Learned, council, pursuant to operating from the state has submitted that he is in receipt of instructions and is going to file affidavit within a period of
2 weeks, Lordship.
within a period of 2 weeks. Stop time period for is granted. The copy of the affidavit is supplied to the opposite party in advance.
Lordship.
Yes.
Deeply.
Item number 4.
Notices have not been served upon the other side.
Yes, Lordship, maybe we may be allowed to take dusty steps, Lordship.
Okay, as per the office report, notices upon the newly added respondents has not been served. It's a net concept for the apple and praise for granted time to take fresh steps for service upon the unserved newly added respondents. Fresh steps to be taken within a period of 1 week on filing of the same. That notice will be issued, registered AD, not dusty, registered AD.
It will be petitioners.
Petitioner.
Item 8.
What's your objections? What are your objections particularly regarding this construction of parking or commercial complex?
Malad, the land belongs to Malad government.
Yeah.
Malad, this municipality has no authority to construct over there.
Is there any objection on the part of the government? Government is objecting to it that this is our land and why the municipality is constructing a shopping complex on it.
Malad,
If the government is not objecting, land belongs to them,
Malad.
what's the problem in that?
Well, the problem is that Malad, it's a narrow place, my lord, where bus stand, bus owners,
These are only apprehensions.
not the apprehension, my lord, they just narrowed down the place, my lord, and for parking of the
What
buses.
about the status of this construction?
My lord, more than 90% has already been completed. Affidavit is.
What remains? We are not supposed to issue a direction to demolish that construction. What is your stand about their apprehensions, Mr.?
My lord.
What is your stand about their apprehensions?
My lord, that is not correct at all. I have filed my affidavit. I have elaborately described. My lord,
Which
my lord,
para?
my lord. Paragraph Page 70, my lord. Second paragraph of para
70.
my lord.
Yes,
It is, my lord, why, my lord, this PIL, my lord, I have stated here in my lord.
read.
My lord, since the establishment of the said public bus stand of the Digboi Municipal Board, a few private bus owners, namely Sri Pranjal Gogoi, Li Sri Dipu Gogoi, and others in the name of private bus owners has an evil eye to illegally grab the and possess the bus stand. They create massive hindrance whenever Digboi Municipal start any development activities inside its own public bus stand. Consequently, they have constructed an office in January 1998 and later an hotel alongside the office building capturing almost 1,000 square feet area of the public bus stands without taking any permission of the Digboi Municipal Board. The private bus owners, Digboi, presently known as Eastern Bus Owners Association, has not made any payment against the current outstanding and dues on 2,66,000, regarding which notice number dated 22/7/2004 and dated 21/10/2000 were already served to the President Secretary of the Private Bus Owners Association, Digboi, by the then chairman of the Digboi Town Committee of so and so, my lord. My lord, because of this, my lord, this PIL.
How this petitioner is connected with?
Connected, my lord, the name mentioned Dipu Gogoi and Pranjal Gogoi is his close friend, but very close friend.
That's very absurd. Close friend, what do you mean by close friend?
And so far, my lord, this, their apprehension is concerned.
Their apprehension that the place will be this squeezed or whatever it may
That
be.
is, that I have mentioned in paragraph 4, my lord, page 73.
Yeah.
That with regard to para 4, the deponent state that objection made in para 4 is totally baseless, as the Digboi Municipal Board is fully empowered under section so and so of Assam Municipal Act 1992, build, maintain and run bus stand aspect as per the decision of the board. Moreover, there will be sufficient space even after construction of the commercial building for the convenient crossing of two vehicles at the same time, having enough space sideways without causing any sort of inconvenience to the public. Moreover, public bus stand is a designated bus stand of the Digboi Municipal Board, and it is never officially allowed any unauthorized whole day long parking of the private buses and any public buses inside the public bus stand. What, my lord, the bus owners has used, my lord, they try to use this as a, my lord, parking place of the abandoned vehicle. That is the main, my lord, reason behind filing of this PIL. That I have mentioned in paragraph 9, para 77.
Malab, they have even demolished the
बाकी तो सब सुनेंगे नहीं, काम खत्म हो जाएगा।
Being heard the consent from the parties, admit not to issue notices, parties are already represented. This, for this matter in hearing for the courts. Yes, in the courts. Next.
Item number 9.
Yes,
May I please, my lordship?
Yes.
you are appearing for?
I don't know, that's from number one.
What
Number one.
about this notices have been issued to respondent number 2, 4 and 5.
As for office, not to service is not.
Service is not complete till date. So
So
Steps
service
were
report is
taken.
not written by.
that service is not, the notices have not been received. And we have already made the notices awaited on 22nd of March 2000, this April 2024. It's almost a month. But will they wait for some more time?
February में थे February में थे February 16 to
Okay, as per the office report. Notices issued to the respondent number 2, 4 and 5 has not been served till date. Learned counsel appearing for the appellant is directed to take fresh steps for service of notice upon the respondent number 2, 4 and 5. Within a period of 1 week on furnishing, on taking the steps, let notices be issued to also registered daily. 4 weeks registered daily.
The 4 weeks. Item 10.
May I please, lordship?
You come.
My lord, in respect of response number 6, my lord.
5 and 6.
6 already demised and I have already collected the information regarding the name of the alert, my lord. So 1 week time necessary to file substitution.
What about 7?
7 already entered appearance.
I'm happy.
And-
I have already filed the affidavit. And what about 6? I'm sorry.
6.
5, my lord, his dwelling place already been shifted. And I need time to ascertain
So
where the
who
correct address.
number 6 or 5?
6 already demised and I filed substitution petition. I have already collected the information regarding alert.
You are supposed to file an application. for-
1 week time, my lord. And so
Okay.
far, my lord, response number
Respondent to the-
7,
Learned, respondent number 7 is already there.
file affidavit, but no copies are upon me, my lord.
I'm ready.
Affidavit on behalf of respondent number 1, 2 and 3 has been filed, you know.
I received.
That I've already served
Okay.
long ago.
Let me counsel for the petitioner has submitted that.
December last.
The notices, appellant करते हैं ना, appellant has submitted that the whereabouts, the fresh address of the note, the respondent number 5 is to be collected. And so far as regarding respondent number 6 is 6, he has already expired and therefore fresh steps are to be taken. 2 weeks time is granted to take the fresh steps on furnishing the same registered AD notice returnable 6 weeks.
I go.
I'm obliged to.
Item number 11.
May it please your lordship.
Yes.
By the order dated 22/4/2024, lordship was pleased to record that the instruction was directly sent to the registry. But
Okay.
yeah, the deputy commissioner is present. So I am here for
About the procedure.
lordship,
That you have
absolutely.
to
lord.
engage the council and thereafter to file your
Absolutely,
response.
lordship.
Yes,
There cannot be any excuse. There cannot be any excuse for that, lordship. They should know.
Absolutely.
In fact, in 2008-9, when my lord Justice BP Kotoke was at that point of time, we had taken an initiative. A circular was issued from the personnel department in 2008. Then in 2018, another circular. And last circular also we issued on 3rd of January this year. On this. That is a problem. I do not know. This is a chronic problem we are facing.
Oh,
They should
Mr. Deputy Commissioner, how you write a letter to this Registrar General direct parawise comment? So we are supposed to that the Registrar General is going to find reply on your behalf.
My lordship, I tender my unconditional apology on this, sir, but
You are not aware about the procedure. For the first time, you are dealing with the court cases.
Sir, lordship, in my previous postings, during the contempt proceeding, I had appointed a learned advocate directly, and he was appearing. When I just got posted here 6 months back, then when this matter came up, my staff, sir, they showed previous cases of 2019 and 22, wherein they filed the case through the registry, and then we appoint a learned advocate through the wakalatnama, and then he
So
comes.
it's a practice there that you directly communicate with the registrar that anytime you a notice is received by you from the court, you directly communicate to the registrar, "Okay, this is my parawise comment and do whatever you want to do."
Lordship, over this, after issuing this, sir, we did appoint one learned advocate, but somehow it.
And what is your response? That I sought information from the circle officer and circle officer has said we are locating for the new land. That's all. It's an order of the court to grant them alternate land, and still you people are sitting tight over the matter that will searching for a new land. What is alternate land?
Regarding this, Lordship, I would like to make my submission, Lordship. The second part, regarding the merit part.
Yes.
Lordship, there are 4 issues. By the learned single judge, there is a direction that the land should be given back, the house should be constructed, or alternatively, the amount should be given, and possession has to be given. These are the 4 directions. And the division bench said that, Lordship, if the direction is that the amount should be quantified and 1 lakh should be paid by 2 authorities. That has already been paid. Now the issue, that is why I would like to apprise this honorable court that the land where they had some shade in the 60s and 70s, those were removed long time back. They filed their title suit and they got a decree in 1999.
Yes.
To get better. And in 2010 also, that was the situation during the eviction suit and etc. Lordship. Now the position is that land was vacant from 2010 and 2019. Guwahati Municipal Corporation has constructed a garbage transfer shed. There is no other, the land is fully vacant. Lordship, I am trying to find out a solution. That's why I'm giving the background.
A contempt petition.
Absolutely, Lordship. So now, immediately we'll clear that garbage transfer shed, hand it back to the owner who got the degree holder, Lordship. There is no difficulty on that. The only problem is that he will not be able to construct any house there.
Why?
Because it is a part of the bill. It's a reserve area.
That is his headache.
That is his headache. So
Who is headache?
absolutely that
The court's order is.
yes,
Deputy
we'll
Commissioner Kamrup and
in
GMP shall
this
put
time, Lordship, we'll
back
hand
in
it over to them.
the-
That headache they will take. But otherwise, we are trying to solve it out. We do
Yeah.
not. My suggestion is that either we acquire it, that is always permissible under that, or else we can compensate him right now. Whatever this honorable court directs. We are in 10 days time, he personally visited under my instruction, Lordship. He saw, initially we had the impression that it is a totally vacant land, which he was found to be incorrect. The deputy commissioner himself saw it. He was relying upon some other officer's version. The other officer's versions are totally incorrect. So that shade can be removed in 1 day or 2 days time. In 7 days, we'll hand it over to them. But it will not be beneficial to the person who will get it also thereafter. Because there is a act which is in place.
Give him a proposal for that. You give him a proposal. If he is accepting to it or that.
In fact, at one point of time when he was not here, there was 2-3 rounds of negotiation with the party. They were shown 2 other plot of lands also, alternative land. They have not agreed. So I don't think that options we can adopt at this stage.
Whatever. If you
Okay,
are,
my submission is, my lord, 31/3/2022, they issue a order, circle officer says this land cannot be handed over, so looking for alternate land. Casually, they came and they moved away, my lord. They have not done anything on this issue. They should have come.
now the Advocate General is offering.
Yes,
that they are ready to give some compensation or ready to hand over the land to you, whatever.
The present valuation is also the court on honorable court quantified as 1 lakh for the house. Now the present valuation is 78 lakhs. If he agrees, we can give it right now also. The option, we have done all exercises, Lordship.
Yes.
Lordship, give me at least a week's time. Let me obtain instruction.
You give it in writing.
Yes, Lordship.
Yes.
I have a written instruction. We'll file the affidavit by tomorrow on this. We want a solution of this, Lordship.
Yes, yes.
Pursuant to the direction given by this court on 22nd of April 2024, Deputy Commissioner Kamru, Metropolitan District, has appeared personally and tendered his unconditional apology for directly communicating with the registrar in response to the receipt of notice of the contempt petition. Full stop. Having considered the apology extended by the Deputy Commissioner, we deem it appropriate. We deem it appropriate not to take any further action against the Deputy Commissioner. However, we would like to observe that in future, we should be cautious in dealing with the court cases. Stop. Learned Advocate General has submitted that the state is ready to either comply with the direction given by this court or to compensate the petitioner with a reasonable amount. Mr. Learned Advocate General plays a week's time to place on record the offer suggested by the state government to the petitioner in writing. List after a week.
Highly obliged, Lordship.
The presence of the Deputy Commissioner, Kamrup Metropolitan District is be marked. That's all.
Highly obliged.
Item number 12.
May I please, your Lordship? Lordship, we have once taken steps, my lord, but
there is a order.
addressee respondent was not found, my lord.
On the last occasion, we granted you some more time. To
Yes,
take
my lord, because
fresh steps.
the petitioner, the given address, my lord, that was not found, my lord. That is why we are trying to find out the correct address, my lord. So we need some time, my lord, more time, my lord. Even we are trying to contact the earlier advocate, my lord.
Again, on the first, we granted you time on 21st of January.
Yes, ma'am.
Then 13th of March, but you have not taken any steps.
No, my lord. First, we have taken steps, my lord, but address was not found as per the service report. So we are trying to find out the current
When it
current
comes to
address.
the respondent please.
Hmm.
10 days more time to take fresh steps as per the order passed by this court on 13/4/2024. Stop. Time played for is granted.
Interim may be
After 2 weeks, interim order if any to continue till next date.
highly obliged. Highly.
Item 14 and 15.
The steps are completed.
My lord, in item 14, my lord, we are the appellants, my lord. And we have taken steps upon the all respondents. Respondent 6 has appeared by filing wakalatnama on 8th May.
Five has now.
Respondent 5 is the appellant in the other case. So
Yes.
Also, we have no instructions.
What do you mean by no instructions?
Same
You
order.
land in one case and in this case you have no instructions, then we'll take a copy. You can get
we'll hand over copy.
for respondent number 6, Lordship. Here, Lordship, we need to file our response.
That's right. Respondent, we are concerned with the respondent number 5.
Yeah.
You are, in this appeal, you are the, one of the applicant, and now you are saying that we are not going to, we have no instruction in this.
Probably the respondent father copy, not yet received the notice yet.
But you are appearing,
Lordship,
the
yeah.
appellant, then accept notice on behalf of him in this petition also. Accept notice. Mr. So-and-so is appearing on behalf of the respondent number 5, and so-and-so is appearing on behalf of the respondent number 6. Copy of the appeal be supplied to the counsel for the respondent number 5 and 6. Yes, copy of appeals.
We have served this about. We'll hand a copy to him, my lord.
Yep.
We'll hand a copy, my lord. Earlier we have taken steps, but we will hand a copy.
You give them a copy, another.
Yeah.
Sir, copy, of the writ appeal to the counsel for the respondent of 5 and 6. During the course of the day, respondent number 5 and 6 may file their response by the next date of hearing, put up after 4 weeks for admission.
Other case we have appeared, my lord.
That is there in. Yes.
Item 16.
The fresh matter or?
It's a fresh matter, my lord. So, they are in filing the appeal, there is even delay of 8 days, my lord. And for that, we have filed
But the notices have been served upon the respondents or?
But this is
steps
not
taken on, my lord, 2 to
steps were taken on
24, my lord.
notice is of 26 too. Then after there is no updated, but only 8 days. Not.
Take fresh steps for that.
My lord, by registered, we can do it, my lord. But by registered post, we have taken, my lord.
But neither any card
Yes,
received,
yes.
notices are not given back till they
Yes,
receive back.
I will take.
As per the office report, the AD card and the unserved notice have not been received till date. When once the applicant may take fresh step for service of notice upon the sole respondent. There is one respondent or
One respondent.
sole respondent within a period of 1 week on taking of the same. Fresh issue notice to the sole respondent, returnable AD.
Okay.
Item 17.
Yeah, please. Also, this is an IA praying for condonation of a delay of 62 days.
What about the service of notices?
Notice.
Everybody is served, not served.
13 not served.
But in the proceeding also, people. Read it to some main.
Who is the respondent number 13?
Sri Kankanjati Lokot.
Kanak Jyoti Lakshar. What's the dispute about?
It's regarding lordship a selection list. Selection happened in 1995. And a petitioner came to challenge in 2006. Dismissed.
On the grounds?
On the ground of delay and latches mainly. There are other grounds also, but mainly on delay and latches.
Lordship, I will satisfy the delay was not on my part, your lordship. There was no delay on my part.
In approaching the court?
In approaching the court, your lordship. Lordships, the advertisement was released on 30 November 1993.
Yeah.
Selection list in 1995.
Yeah.
After that, the candidates were not selected. They preferred petition before the Honorable High Court. And then the judgment was delivered in 1997. After that, there was an appeal. In the appeal also, it was held that the selection list is declared to be invalid. So all the appointments as per the selection list were invalid.
Then the appeal was decided in which year?
Appeal was decided in the year 1999. And it was directed that fresh advertisements should be
Then
given.
you approached the court in
Lordship, I approached firstly in the year 2006. The reason
1999 to 2006, 7 years later.
Yes, Lordship, the reason is that in the appeal, it was said that a fresh advertisement should be given by the department, and they gave the fresh advertisement in 2002, and I applied. After that, I came to know that few to the candidates from the selection list, they have been given appointment in the year 2000. So accordingly, I approached the court in 2006.
By the time he came, he was around 52 years. So that now by giving him the negative equal will also will be applied. And now I present my 52 years ago. Can I just? Well, how old are you now?
I am at the verge of around almost 60, Your Lordship.
I think you have retired
54 years.
today.
Today, I'm 54 years.
Almost you have completed your.
Your Lordship, I mainly agree by the observation of the learned single judge that there was delay on my part. Your Lordship, the 2006.
Okay, we'll ignore that and we'll dismiss your petition on the ground that since you have attained the age of around 55 years, no point in giving any relief to you.
But Your Lordship,
You are agreed by that only.
may I submit one more thing, Your Lordship? Your Lordship, I preferred a repetition in the year 2006.
Yeah.
That petition was disposed of in the year 2009 with an observation that whatever information I'm seeking, it should have been from the RTI. So I should move to the appropriate forum. I approached the appropriate forum. I got the information. Then I came back to this court in the year 2010. And that writ petition, this instant writ petition was disposed of in the year 2013. It was dismissed. I didn't come before this honorable court with an appeal. It is they who came with an appeal saying that the observation there was that the selection list is illegal. Since the selection list is illegal, all those appointments that have been given, inquiry report was sought for, and the inquiry report said that their appointment is illegal.
We admit that there is no delay on your part. But so far as regarding equitable relief is concerned, that now at the age of 55 years, we can't direct them to give appointment.
But Your Lordship, they have kept me in this litigation for so long, since
Give
2013.
me appointment from back date and all consequential benefits and everything, you'll ask for heavens now.
Lordship.
Yes, what Lordship?
But Your Lordship, I was in this litigation just because of them since 2013. They say that they will file a reply. They need to
This
have a
appeal
say.
also you have filed with the delay.
62 days, Your Lordship, because I'm unemployed, Your Lordship.
You approach the learned single judge with delay, and on this ground, your writ petition was one of the ground. And now again, you have filed appeal also with delay.
62 days, Your Lordship, that may kindly be considered, Your Lordship. I'm an unemployed person. Earlier, the previous set of councils, they didn't prefer to go for the appeal, so they have approved.
Then get the notices of the respondent number 13, sir.
13.
13, naturally.
Was not.
So 13 upon the 100.
13 private respondent.
बाकी का वॉइस देख लो अपना वीडियो में
It's not a state of.
तो अच्छा चॉइस
That's true. That's true. Sir.
Get the notices of this application on the respondent number 13, sir.
Lordship, I will read that.
I am appealing for state respondents, Lordship, 1, 2, 4, and 5. Lords.
Okay. The notice of this IA has not been served upon the respondent number 13. Till date, the concept of the petitioner, the applicant pays for an granted time to take fresh steps for service of notice upon the respondent number 13. That to be taken within a period of 1 week registered daily.
Right, Your Lordship.
Item 18.
Okay, first.
Yes.
May I please, Your Lordship? This non-compliance of the judgment dated 1710, it is start from page 11.
Page 11.
Property portion, Your Lordship, to page 21.
21.
Paragraph 13, Your Lordship.
6 month time was
Because
granted.
of action, we are like, all legal heirs of MP Jalan to sort out their differences and to reward the respondent corporation for reconstitution of the firm. The above process have completed within 6 months. The respondent committed the liberty to take and give the beginning of and some challenge will be low profit the hand. Holiday.
That 6 month time is already expired on 14/4. But till that, the respondent corporation,
So, you are the legal heirs of MP Jalan.
lot.
You have approached that.
Approach them, your lordship, because there is a dispute, your lordship, among the legal here, they are not
Jalan
sort
to
out.
sort out the differences, to revert to the respondent.
Lordship. Among the legal heirs, one of the legal heirs has been running the petrol pump and he is claiming 50%. That is the case here.
There is question of content.
Question your here, liberty is granted to the IOCL to sort out the liberty is granted to take appropriate action as per guideline after expiry of 6 months.
Peculiar, we hereby give liberty to all legal heirs of MP Jalan to sort out their differences and revert to the responding corporation for reconstitution of firm. So, we have already sorted out your differences.
No, your is not sorted out. That's
Then where is the question of contempt? If you sort out your, if you are able to sort out your differences, then only IOCL has to take action.
No, your lordship. If it is not sorted out, the IOCL will take action as per guideline, your lordship. After 6 month time, that is granted. After expired 6 months.
Guidelines?
If the above said process is not completed 6 months, the respondent person liberty to take it as per guideline. Your lordship, guideline, your lordship, page 20. Paragraph 11, your lordship, it is discussed about guideline. Because one of the legal heirs is running the petrol pump since 2012 without paying the share to other legal heirs, your lordship. That's the question.
Where are the guidelines?
Page 20. Page, your lordship, 20, it is stated, paragraph 11, your lordship.
Yeah.
Under subclause state of clause G of the policy guideline, in case of temporary arrangement for operation of the dealership continues beyond 6 months, the option has to be given to the corporation to run the dealership under the holiday scheme to the surveying partners for sorting out their issues within a reasonable time and revert back for the dealership ownership. Under this clause, the burden is upon the partners to come out saving about solution, failing which the corporation would be have to proceed under clause 10G of the resolution.
What initiative you have taken for this sort out your differences?
Because one of the legal here, he is running, but he is not.
That's right.
That's
But
right.
what steps you have taken?
We have approached your
You are one of the legal heir of MP Jalan.
lordship.
What steps you have taken to sort out the differences? Have you had any meeting with the person who is running the petrol number one?
Lordship, I have approached him, but he is not
Where is that?
interested.
What efforts you have mentioned in your petition?
It is mentioned in the budget. Paragraph 6, your lordship, page 6.
Page 6.
Lordship.
Yeah.
The petition backstitched on 6/11 to the petitioner submitted certificate to the so and so. The writ petitioner said Rajesh Kumar Jalan has been claiming 50% share of the petrol. Therefore, the matter is not settled among the legal heirs led Dr. Jalan. Rajesh Jalan has been enjoying 100% benefit of a petrol pump. Therefore, he is not interested in the reconstruction of the above the petrol pump. Though the petitioner and other legal heirs of Dr. Jalan tried to settle the dispute, but due to adamant of Rajesh Kumar Jalan, it has not been settled. On 8/4/2024, the petitioner visited the office of the opposite party and verbally intimated the opposite party about the state of settlement among the legal heirs of late so and so. And on other, he
You
submitted
have approached the IOCL authority that
lordship. After that, I said page 25 years. 8/4. It is received on 9/4.
It's some private between them.
Old is it mother and other legal heirs in one side and one brother is in.
notice returnable 4 weeks. Registered DD.
Obligation.
Item 19.
An application for condonation of delay, but step was taken on 18/4/2024, my lord, as per office note dated 9/5/23.
What happened to the service of notice?
Notice has not been served, my lord, nor the AD card has been returned, my lord, as per office note dated 9/5/20.
Fresh steps. Fresh step for service of notice one week. Registered AD.
Must submit.
Item 20.
Press steps will take matter because neither notice nor AD card has received back matter after waiting for another 2 weeks.
Fresh step, same order.
Obligation.
Item 21.
So in this case, office note indicates that neither the AD card nor the unserved notice has been returned back.
Fresh. Same order.
Item 22.
With your lordship. There is a delay of 46 days in filing the appeals. Respondent has appeared and filed their objection also.
Well, paragraph 6 may be seen on my objection. Paragraph 6.
We are appealing for all the respondents.
Sole respondent. Sole respondent. Paragraph 6.
Paragraph 6.
Yes.
Yes. Page 13. Page 13. Sir. One.
That officer was not a party, my lord, earlier, my lord. That's why.
This, he is not the officer in charge.
That is the, my lord. In the original writ petition, he was not a party, my lord.
So how it is concerned?
Now they have filed it, my lord. Saying that he is the.
Original, this.
I have annexed the judgment, my lord.
Company.
Annexure A.
Annexure A, yeah.
My lord, you will see the respondent, my lord.
Indian Oil Corporation Chairman
Yes.
and this Chief Manager.
Chief General Manager, my lord.
Then
Number 3 is General Manager HR. And number 4 is Chief Employee Relation Manager. And number 5 is Senior Employee Relation Manager.
fine. Now this affidavit is filed by whom?
This appeal is filed by one assistant manager, my lord. In paragraph 1, your lordship will file of their IA, my lord.
Yes.
Paragraph 1, your lordship will see he has stated that he is a assistant manager employee relation.
The applicant begs to state the applicant in an government undertaking by the represented by a person employee relation who is duly authorized to prefer the application and take all necessary steps connection to direction. Does employee all the citizens are.
And if your lordship will see.
Officer of the IOCL is authorized. What is technical objection you are raising, sir?
Well, initially he was not a party in the.
Whatever it may be, he is an employee of the IOCL. This is the only objection.
Yes, yes.
Was the matter on merit?
Regularization of a
Merit,
the earlier proceeding here, he was not here. He came up. Then the pre-taking was over.
If you have regularized the services of the employees, what's the problem?
My only condition that was my lord made. He came, my lord, after 22 years. Now he's objecting to 46 days delay. He approached this court, my lord, after 22 years. And my lord, my submission was that he was a fence sitter. Therefore, my lord, relying on the decision of the Supreme Court, this ought not to have been given. That has been, my lord, stated now.
There was a common notification.
Yeah.
The matter comes from the IA, this IA is filed on behalf of the applicants with a prayer to condone the delay of 62 days in filing the connected appeal. Some objections have been filed on behalf of the sole respondent regarding the condonation of delay, having heard the learned counsel for the parties and after going through the contents of the IA, we are satisfied that the delay of 62 days in filing the present appeal has been sufficiently explained by the applicants. Hence, the application under section 5, the IA number so and so is allowed. Delay of 62 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and listed for admission after.
After 2 weeks, my lord.
2 weeks.
All right. My lord,
The appeal, copy of the,
I have not received any copy. I will serve copy.
yeah, you submit.
Oblige you.
Item 23.
Yes, item number.
23.
Lordship, as per office note dated 9/5/2024, we need to take fresh steps upon respondent number 4 in this.
Sir, respondent has not been received. Fresh steps for respondent.
What is the comment?
And moreover, Lordship,
Director.
Director of Welfare of Plain, I think they have a standing council. Mr. Paul, who is the standing council for WPTBC now? Ad hoc. Oh, please, sir.
You are appearing for respondent number
number 4.
4. Then they click here. So, how many days did they have there?
Lordship, I have a prayer, your Lordship.
93 days did they?
I have a prayer, your Lordship. While filing the appeal, inadvertently, the respondent number 4, who was the party in the writ petition, District Elementary Education Officer, Karimganj, that the respondent number 4 was inadvertently left out. So on Friday, we have filed an application for adding him as a part, the respondent number 4 as a party. So that IMA can be checked with this appeal.
After a week.
Much obliged.
Item 24.
That's 3 years. That's it, really.
May it, Lord. But here, the notice upon the respondent
Question, delay,
has not been completed, my lord.
service not,
Service not complete.
Yes, sir.
notices were issued on 4/4. But.
Await detail of notice of respondent number 4, for 3 more weeks.
Oblige, Lordship.
Item 25.
Okay, 25 and 26 are from the common judgment by the CSET Lordship. My learned friend is appearing item 25. And
You are appearing?
My lord, in item 25, I am appearing, and 26, my lord, they have not,
26, the wife of the
wife of the, my lord, but they have not, since they have not received any notice from the court, my lord. Today I'm,
Or you are waiting for your material instruction.
my lord, because I'm appearing for the first time in this matter, my lord. Because there are 3 parties, my lord, one the firm, and wife is the proprietor, and husband is the power of attorney holder. So, my lord,
you know, 26 notice was,
Accept the notices on.
my lord,
Okay.
there is a delay of 33 days in preparing.
What about the delay?
33 days, I'm not objecting.
Fine. So put in appearance on behalf of the
35 would have.
respondents in the above referred,
I would have-
respondents in both the IAs. Let's stop. The IAs are filed on behalf of the appellants with the applicants with a prayer to condone the delay of 33 and 31 days respectively in filing the connecting references. Full stop. Having heard the learned counsel for the parties, we deem it appropriate to condone the delay of 33 and 31 days respectively. Hence, the IA number 908 of the 2024.
Who's raised, who's mistaken this for 9-0. 9-0, it should have been this. But mistake हमने order sheet भी यहाँ पे आ गया है, but actually ये आपका जो mistake है, ये गलत चीज है, तो लास्ट ये होने के बाद ही ये गलती थी, तो रेस पे उसको करेक्ट कर देंगे लास्ट में एक लाइन.
In case, the Mr. Show is appealing on behalf of both the respondents in the on behalf of the respective respondents in IA number 908/2024 and IA number 512/2024. It appears that the registry has registered the IA number 908/2024 inadvertently, though it is an stay application. Full stop. The application for condoning the delay is not registered. Full stop. This notice registered. The connecting custom references are filed with a delay of 33 days and 31 days respectively, having heard the learned counsel for the parties. And after going through the contents of the IAS, we deem it appropriate to condone the delay of 33 days and 31 days in filing the connecting custom references. The registry shall correct the registration of the IA number filed in custom reference 15148/2023 in bracket filing number, and thereafter to register the custom references and place before this court after 2 weeks for admission. Okay. Copy, you give the references.
I'll supply copy.
Okay. And here the
25 minutes.
For admission, item 27.
Very good. Single judges. Not even challenge the finding of the inquiry. When come to
Lordship, I am for the respondent. One aspect I just wanted to point out, Your Lordship, in the appeal, Your Lordship, the enquiry report and the minutes of the disciplinary proceeding, Your Lordship, which was part of my writ petition, has not been annexed, Your Lordship. I would have been pointed out.
Mr. Counsel, we are of the opinion that this person being a bank employee, though no financial loss has been suffered to the bank, but ultimately it's a matter of loss of confidence. Not a simple matter.
Lordship, that's.
You have to hear it, sir.
Lordship.
You have to hear it. लिखिए issue notice when it concept for the respondent has submitted that some of the documents annexed in the writ petition has not been annexed in this appeal. When it concept for the appellant undertakes to furnish those documents within a period of 1 week, having heard the parties for admission. Having heard the counsel for the parties, we deem it appropriate to stay the effect and operation of the impugned judgment passed by the learned single judge
23/5/20.
23/5/2023. List this writ petition, list this appeal for admission after 3 weeks.
Lord, may I make a prayer, Your Lordship? Since it was a compulsory retirement, Your Lordship, he is entitled to pension, Your Lordship. During the pendency of the writ petition, Your Lordship, he was not paid that pension, Your Lordship. There was that may be, Your Lordship.
In the meantime, the respondent, the appellant bank may proceed for grant of pension to the respondents, treating him as treating his services as compulsorily retired.
Lord, may I please, Your Lordship? Your Lordship, the same question has been raised before the Honorable Single Judge, Your Lordship. And at that time, we have also made in submissions that subject to the filing of their appropriate application before the bank. Till date, they have not proceeded with the pension. Your Lordship.
Mine, I will, if necessary, Your Lordship, I will do that.
Move that application, that you proceed for that, at least for pension, treating him as.
Yes, yes, we are ready, Your Lordship.
Proceed further.
We are ready, Your Lordship.
Yes.
Deeply obliged.
Item number 30.
May I please, Your Lordship?
Yes.
Lordship, there is an amicable settlement is going on between the parties, Lordship. Lordship, so kindly 2 weeks time may be given, Lordship.
For what?
For amicable settlement is going on between the parties, Lordship.
Amicable settlement, whether they are regularizing your this
Floors.
floors, the illegally constructed floors,
Yes, Lordship.
they are regularizing.
No, Lordship.
Then what amicable settlement you are? You have to demolish those additional floors which you have constructed without seeking any permission.
Lordship, writ petition is also pending, Lordship. It is fixed on for hearing, Lordship.
Then pursue that writ petition by this appeal.
Lordship, there is an order passed by the single judge, so Lordship, this order
The
was.
learned single judge has passed now, the learned single judge issued the notices and refused to grant the stay, that's all. We don't find any ambiguity in that order.
Relevant
Lordship,
52 and 53.
as by my senior instruction, Lordship.
And counsel has submitted that. The senior, the arguing counsel is not available. Adjourn for a week.
Obliged.
Yes.
Item 24.
Right, Your Lordship. Looks the appellant has got a very limited prayer here, this matter, Lordship. Very limited prayer, Lordship.
Limited prayer.
Lordship.
If that limited prayer has not been granted even by the learned single judge, how can we grant another?
Let you place the matter, Lordship. That petitioners, Lordship, that land and the three-story commercial building has been acquired for widening of the national highway.
Yeah.
Now, Lordship, that thereafter, the present value of the building is about 5 crores of rupees. It means PWD assessed the value at in 1922 at 2 crores something. Now, Lordship, there is no case has been registered, no land acquisition case has been registered. All of a sudden, Lordship, that on competent authority on 28th of January 2023, passed an award of rupees 3,39,000 rupees.
3 lakhs or 3 crores?
3 lakhs only 30,000 rupees. That is the preliminary. Initially, they do it, Lordship, without making much here. Then on 15th of March 2023, they passed another award of 1 lakh rupees. Total about 3 lakhs, 4 lakhs total, Lordship. But the building was while PWD assessed the building in 2022, they said it's a 2 crores something. Now, Lordship, that this was done, Lordship, under section 3G of the National Highway Act.
Yes.
3G National Lordship. No. 3G of the National Highway Act, Lordship, it says determination of amount of payable as compensation. May I read it, Lordship? 1. Where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competent authority. Now, clause sub 5 says, Lordship, if the amount determined by the competent authority under subsection 1 of subsection 2 is not acceptable to either parties, the amount shall, on an anti-application by either parties, be determined by the arbitrator to be appointed by the central government. When our Lordship, that we are not satisfied with that very meager amount that is given,
Then
so we
that's
file
what
an
the Leonard Singhal judge has said.
Lordship, we file an application under to the arbitrator. That is not even decided. Now, the finding no
Once
alternative.
the assessment is there and you are not satisfied with that, then go and find that reference, that's all.
No, we have filed Lordship arbitration. That has not been disposed of. Decided.
So, pray for this, whatever stay you want, pray for that in reference proceedings. How this court can grant now a stay?
No, because the finding no alternative, what they have done, Lordship, that under section 3H very clearly says that the amount determined under section 3G shall be deposited by the central government in such manner as may be laid down. Last portion, Lordship, before taking possession of the land. Before taking possession of the land, the amount must be determined. My amount has not yet been determined, Lordship. But,
Yourself has said they will determine.
no, because we sent it to the arbitration. It's under 3G includes arbitration also.
You are not satisfied with the determination, that's why only you filed a reference before the arbitrator now. Or approach the arbitrator for that.
The arbitrator hasn't decided. Arbitrator, that clause 5 comes from under 3G. So once such a dispute arises with application, once that is determined, then only the possession can be taken, amount must be paid. Now, my simple prayer, Lordship, we file a writ petition.
That's all, nothing.
So, lot of people, if they take over the building and then demolish the building, so that they not made that assessment, what payment I will have, Lordship? Let them make the assessment, they are compelled to make the assessment.
They already mentioned, already reassessed.
No, they have not.
This is what
Lordship,
their
kindly see.
intention.
No, Lordship, kindly see the affidavit filed by them, National
Yes.
Highway.
Affidavit in opposition, yes.
But yes, Lordship will kindly turn to page 161, Lordship.
That is the starting.
Which is the relevant para.
Lordship, I'll read it, Lordship. Para 7, Lordship, based on which the Honorable Civil Judge has vacated the interim order. Para 7.
Yes.
That before declaration of the award under 3G of the Act, joint carried out by officer PWD along with the Revenue Department, Agriculture Department, etc. And details were recorded at the site. As per JMS report signed by the representatives of the concerned department, the details of the said land, Zirat and structure are given as below. This is the annexer, annexer 3. Annexer 3, in fact, doesn't indicate anything, any assessment, nothing. That's at page 179. Annexer 3 there, but it doesn't indicate any assessment, any amount, any determination of reward.
And finally, this approach the Leonard Singhal judge for clarification.
So, Lordship, that I will, because they suddenly vacated. Lordship, will kindly see para 9. Para 9. Para 9 is the report submitted by the PWD on the assessment at the request of NH. Lordship, compensation amount of the structure at such and such. The CALA, Competent Authority Land Acquisition, recently submitted the 3G estimate of structure against that number such and such. Number petitioner White later with a request to cross-check the same. Upon perusal of the said estimate, petitioner, it has been observed that it was not prepared as per the actual joint measurement. National Highway requested PWD made an assessment. That was about 1 crore rupees something, but some technical flaws there. Lordship, we can turn to page, Lordship, Annex 5, page 183. So immediately, Lordship, that but my simple prayer, Lordship, just lay this day which was granted.
Yes.
Look, this annexure shows that
Whatever it may be, sir, once if you are finding fault in whatever the documents they have submitted, point it out to the learned single judge that you have not
the
appreciated
interim
those
order may
documents
continue.
properly.
The interim order may continue. That was
No,
given.
can't be, sir.
That was vacated. Lordship,
No,
can
you approach the learned single judge with that you have this appreciation of the documents which you have made is not correct. That's all. We are not going to interfere in these matters, sir. How can that writ petition is still pending?
Yeah, it's pending. We want that.
No, not at all. Sorry. Be careful. This writ appeal is filed by.
He conclusion in writ petition, Lordship, and
Why the order dated, being agreed with the order dated 4/4/2024, passed in writ petition number 5324/2023, whereby the learned single judge has refused to extend this interim stay order while observing that the assessment of the property in question has already been completed. And notification already issued under section 3D National Highways Act. As per which property rests in the government, therefore, the stay cannot be extended. The extended, having heard the learned counsel of the appellant, we are of the opinion that no case for interference is made out. However, if petitioner, if the appellant wants some clarification in respect of the order passed by the learned, in respect of the interim order passed by the learned single judge, he may approach he is at liberty to approach the learned single judge.
obliged.
Item 35.
Delay in delivery of the vehicle, my lord, 6 days. My lord, I find, my lord, one documents.
Yes, Mr. Chaudhary.
My lord, we had a discussion in the matter. In fact, one of the officers came down also. My lord, they are of the view that a show cause notice was served to them which is suppressed.
No.
Show cause notice was issued. Whereby, my lord, he did not place the vehicle within, sorry, he did not place the order within 7 days. That was, he said, he made a statement in the writ petition that he has done that is not factually correct. Then, my lord, he could not place the vehicle within 2 months. Now, what had happened, my lord, along with the appellant, 2/3 of the work was given to another party. In fact, he was given 3 ambulances, they were given 2. So on similar footing, my lord, their orders have also been cancelled. So in all, there were 5.
No, but they have also procured those ambulances.
No, they also could not, my lord.
But he is here, he is with the ambulances, sir. He is standing in front of your hospital.
No, my lord, the difficulty is there is a stipulation of two months that he have given beyond 2 months. My lord, I had a
7 days delay is there. You impose some penalty, he is ready to pay for.
No, I have given a document where in similar circumstances, when 45 days delays were there, they've imposed a cost of 67,000. That document.
67,000 rupees.
Initially, they have counted as 95, subsequently they have imposed 67,000.
So how much you?
45 days
you-
delay.
You offered to pay how much for this penalty?
Man, 50,000 rupees, kind of delay of 6 days, my lord.
Not 6 days, 22 days.
According to them, my lord, if I go by jam contract starts from 18.
22 days delay is there, 3,000 per day. No.
My lord,
Ambulance is just delivered, my lord, loan is there, we are.
my lord,
required to
our, my lord, if it goes as an order of the honorable court, I've got nothing to say, my lord, but also will not record our submission because, my lord, audit and all this to clear that the officers will be in trouble.
Okay, that's fine. No doubt. This is the order, impute order is?
Yes, my lord.
Where's the impute order?
Page number, yes, it is there. Page 166.
Just, there is no, to say any observation on merits, simply stay has not been granted.
Stay has nothing.
That is at page 166, if you know.
Or London single judge can also be requested to dispose of the matter maybe within a week's time, my lord. We'll file our reply.
That's very difficult because we don't know about the pendency of that. Where is your stay petition, Mr.?
Stay petition. Oh. Yeah, no.
What do you have paid in the stay?
Stay of this impugn order at page 166.
163.
Separate I file person, नाही तो करा. नाही करा ना? First day. आम्ही फोन नाही घेतली. Anyway. Show cause notice. Just for the record, my lord, that show cause notice was issued to them.
I have annexed it. 2 notices were issued to us. We have an.
The notice issued to you.
For page 132, my lord.
It's on record.
I have given detailed reply.
132. No, this is not the notice. That's a
Two
separate
notices.
one.
Two
23,
notices.
22, 3, 24.
Yeah, that is at 179.
And यहाँ पे उन्होंने सब नोटिस किया but he did not count them.
That is at 179, my lord.
Okay. The appellant has approached the London single judge, well, approached this court by way of filing writ petition number 2314/2024, challenging the validity of the order dated 20th of April 2024, whereby the contract awarded in favor of the appellant by the respondent IOCL has been terminated. As per the contract, the appellant was supposed to deploy 2 new ALS ambulances to the IOCL for that hospital is there or what?
Yes, my lord. Hospital is there.
Hospital in the refinery concern, in the concern refinery. Stop. The IOCL has terminated the contract of the appellant as he failed to deploy 2 new ambulances within the stipulated time, that is of 2 months. The net council has submitted that the ambulances could not be deployed as the dealer has delivered the ambulances with a delay. Full stop. It is also submitted by the council for the appellant that the ambulances are now deployed, but the respondents are not using the said ambulances on account of termination of contract. Full stop. It is contended by the learning council for the appellant that despite recording the submissions made on behalf of the appellants, learned single judge has not passed any interim order. Full stop. Having heard the learned counsel from the parties and in the peculiar facts and circumstances of the case, you deem it appropriate to direct the respondents, IUCN, to use the two new ALS ambulances deployed by the appellant subject to the condition that the appellant shall pay a penalty of rupees 50,000 to the respondent IUCN within a period of in
3 days.
in next 2 days.
Yes.
In next 2 days, the appeal is disposed of. Learned single judge.
Petition can,
We can dispose it of the writ petition also. Yes. What remains that writ petition?
or else by law, it will so happen.
I've shown my lord
That
in
lordship will only consider
similar
the
circumstances.
interim part. And Leonard Singh is just open to decide on marriage.
There's nothing in that to decide on merits.
No, no. If your lordship keeps the single judge's matter open, that will be the inference.
Then we'll decide it. The writ petition itself. Full stop. And what is in the comment?
There are two writ petitions, my lord. 2084 of 24 and 2314 of 24.
Same, this, same dispute.
Same subject.
Those are also infractions,
Those are infractions.
because those have been filed, my lord, against the notice, my lord, we gave reply.
That has been taken back.
Yes, it will become infraction.
Next 2 days. In the above facts and circumstances of the case, the order of termination of contract dated so and so
24.
20th of April 2024 is set aside. The writ petition filed by the writ petition number so and so filed by the appellant be treated as disposed of. And another writ petition against which you have not filed any appeal.
No, 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 that is against the notice, my lord, that has become an infraction of your lordship.
Of the writ petition number so and so, this writ petition and another writ petition.
2084 of 24. That my learned friend is saying has become infraction.
Be treated as disposed of.
Yes.
Both the writ petitions be treated as disposed of.
It has been too late for it.
Hello, WPC 171924 and this one. We can bring it in.
issue for the moment.
I mean, you have to be treated as disposed of the registry will take care of that. Treated as disposed of in terms of the call, the registry will take care of it.
Item 26.
Yeah,
Yeah, please, Your Lordship. My lord, the challenge here in this case is, my lord, again the demand as well as the position notice, my lord, issued under the Surface Act, my lord. My lord, the deceased husband of the petitioner, my lord, obtained loan from bank.
So you have alternate remedy to approach the DRT.
My lord, already, my lord, position notice has been issued.
Whatever it may be, you approach the DRT for that. And this court is not supposed to entertain these petitions under Article 226. Recently, the Supreme Court has also ruled.
My lord, in the meantime, my lord, they may
Not
be.
meantime, sir, if we are not entertaining the petition, how can we pass an stay order? You approach the DRT.
Because, my lord,
Yes. Withdraw it with liberty to approach the DRT.
my lord,
Then comes after attempting to argue the matter for quite some time, and may consider the petitioner on instruction has submitted that he does not want to press this petition now. He wants to withdraw this petition with liberty to approach the DRT. Under the Securitization Act, dismissed with liberty as spirit form.
my lord, in the meantime, my lord, no coercive action.
Sorry, sir.
Oblige me.
Yes.
Item 27.
असं ना केस नंबर किती? We have
Then this matters were fixed. And similar matters we.
Yes, all with petition 2344 of 2024 and 2303 of 24. Yeah,
We have they fixed some date now and that.
it was listed after 1 May.
Respondents have placed some time to file their response. And I think so the matter is pending before the Supreme Court. Also.
Yes, only your lordship, if I may submit in the form of a prayer, if these two petitioners can be permitted to at least start the screening process. Screening because your time is the essence, your lordship.
That's right.
And in keeping their, if they are not found eligible, matter stops there.
Right. That's
At least the screening, if their heart is not functioning properly, it can be. If they are diabetes and they cannot go to the screening.
They need to have the permission of the court. They can do it on their own also. When I go to you need to if you go to the clinic and if you maybe there can be all those cases from that. But prior to that, anything but for that, Mr. Senapati, why do you require an order of the court?
Because
the actual procedure when it starts.
No. The assessment by the respondent number 5 cannot even done as per section 21.
You don't do it in that sense. You continue your assessment.
That if your lordship permits,
For that
just one
permission,
observation.
no, there is no when the procedure, because the Supreme Court has also said persons who have already been into it, they were permitted to consider. Others were not allowed. The other high courts have also done. For the preliminary consideration in that, why? HIV, blood sugar, glucose test, for that, any hospital can do it for you.
That means it has to, because it's like this, your lordship. One of the observations that I find from this act is that commissioning couple, that is the husband and the wife, are not permitted. The role of a man, the age is prescribed in 21G. But for a sperm donor, no age has been there.
So if
There may be some correlation between that, they have, the, whatever this, the differential which they have created, maybe on some scientific.
no, absolutely, that I will satisfy your lordship, absolutely not.
That's for them.
I'll show the parliamentary report that is.
Let them
Yeah,
have
yes.
their response to this, then only we'll consider. Yes. Yeah, we have issued, then accept the notices in this also. And file your response. Okay, Mr. So and so, issue notice, Mr. So and so. Put in appearance on behalf of the respondent number. Respondent number 1.
To Union of India. 3,
1,
1 and 2, 3 would be.
1 and what about the others?
I am appealing for reference number 4. See between the National Medical Commission.
What is the need of this National Medical Commission?
In case your lordship wants to go for any medical opinion from them, that what is the,
Without being implemented as party, we can.
Yeah, absolutely.
We can, issue notice to the respondent number 1, 2, and 4 for the time being. And this IVF center.
because I thought about the prayer.
There is a bar, so what they will do? 1, 2, and 4. Mr. So and so put in appearance on behalf of the respondent number 1, 2. Mr. So and so put in appearance on behalf of the respondent number 4. Copies of the written petition be supplied to them. This thing.
No.
Along with.
Other
For 2 weeks, after 2 weeks, along with so and so, so and so. Mr. I'm thankful that you have conferred a master's degree to me in your title. MA LLB, though I have not done any MA. Thanks for that.
Much obliged.
Number given.
Item 38.
May it please your lordships.
Yes.
My lord, the challenges to the order of the honorable tribunal.
Compulsory retirement.
Compulsory retirement with a cut in the pension restricted to 5 years by the appellate authority from a previous permanent cut in pension.
Charges are heinous.
My lord, the charges are heinous, but the orders of the discipline authority and the appellate authority have not gone into the facts of the case. That I'd like to convince you.
I mean, the effects of the
On-
case.
on the-
There are
on the-
statement of the victims
On
that you have harassed them.
Well, there are 3 persons present in the room, witnesses present in the room. 2 of them have not heard anything. They have stated on.
That's what the tribunal has
And disbelieved them.
created, that how it is possible that in room 3 persons were there and 2 of them not had any conversation between them.
Yes, well, that aspect had to be deliberated upon. And secondly, my lord, that the complaint does not mention the specific allegation.
There is drunkard also and everything. In fact, and
That
not,
charge was
not
dropped.
only this lady, you are indulged in these behavior with other ladies also.
That charge was dropped as not being proved. That is, the appellate authority has held it to be proved, but that was dropped by the disciplinary authority as well as by the inquiry committee.
Admit, issue notice. Returnable 6 weeks.
I'm obliged, my lord.
Item 39.
In this matter, the government is yet to complete filing of the affidavit.
Yeah, on the last occasion, you dropped time for filing.
My lord,
Respect of some of the districts.
my lord, this case is handled by Mr. R.K. Bora, my lord, because of his, my lord, marriage at home, my lord, he could not come today, my lord. Lordship may kindly fix it, my lord. He informed me, my lord, he had to receive 2, 3, my lord, instruction from 2, 3 deputy commissioner. My lord, because of the my lord, election, they could not provide the documents in time, my lord.
Okay, Mr. Mr. So and so has submitted that Mr. R.K. Bora on due to some personal reasons and is not attending the court today. It takes some time for adjournment, 2 weeks.
Obliged.
Deep.
Item 40.
May I please, Your Lordship? I'm appearing on behalf of Seema Goya. Actually, she is not well. She's taking more time for file her affidavit.
Okay. A request is made on behalf of the petitioner that since she is indisposed, the matter may be adjourned. Adjourned.
Item 41.
I pray for adjournment in this matter, Lordship, my signal is out of office.
What is your business that there are illegalities in construction of the medical college? Are you an expert or what?
They have taken offense to that.
But there are some discrepancies here.
Affidavit from the commissioner. Info engineering that will happen. It has been the reply just like this one, but it's gonna be back. It's
Yes, the respondents have rightly said that. What is your, are you engineer or what? And you have taken very, it's very offensive that how you can comment like this. So any person having no knowledge about the technology or something or this, come and say that there is some illegality in construction of so and so building. We allow such type of persons, then certainly it would be very difficult for.
the petitioners take out all the information from the reports made by the annual petition. And the petitioner does not have basic knowledge and not having friendship to understand the technical. That's the right thing.
Yes, what do you want?
Lordship, next week, any date, Lordship, today is my senior is out of.
Lordship, this is going on for the last 1 year, Lordship.
The construction is going on.
No, Lordship, the hospital is functioning since April. Yes, Lordship.
Admissions are in.
Since 2023, Since 2023. Yes.
Lordship, last of, on the next date, Lordship, may hear my senior.
Responsible the respondents have informed that the building of the medical college has already been, the construction of the new medical college building at Nalbari has already been completed and the medical college is functioning since 2023. Full stop. In view of the above situation, we are of the view that this writ petition filed by the petitioner essentially raising a grievance that there are certain irregularities in construction of the new medical college building at Nalbari. Then counsel to the petitioner has submitted that the arguing counsel is not available to me. This matter when day after tomorrow?
Lordship, Friday.
Tuesday. It's come like Tuesday.
Item 43.
May it please your lordships. Lordship, the state government, as per the order passed by this honorable court on 19/4/2024, has filed the affidavit bringing on record regarding Kamrup Metropolitan, my lord. And in the affidavit, it has also been stated that they have sent for independent examination in one of the institutes at Guwahati.
Two of them.
And one at Kerala. So, my lord, those reports may be awaited. But in the meantime, my lord, one thing, if I may kindly point out, my lord, there is one major error in the affidavit which has been filed. If your lordship kindly has page number 172.
Yeah.
My lord, the second paragraph, last line, according to the FSSAI, if your lordship has found it.
Yeah.
According to the FSSAI, the maximum limit of naturally occurring formaldehyde in freshwater fish
is 40 mg per kg, and in brackish or marine fish, it is 100 mg per kg. My lord, this statement is absolutely false, and I can show that from page number 87 of the records, my lord. Page 87. Notice. This is notice for operationalization of food safety and standard food product standards and food additives amendment regulations.
Yeah.
Yes.
But for freshwater, my lord, if your lordship kindly sees at page 88.
Yeah.
Group 3, for freshwater fishes, it is 4.0 mg per kg, my lord, not 40 mg per kg.
It appears there must have been a typographical error, Your Lordship. I'll get instructions.
And secondly, my lord, for marine fish also at page 87, it is 4.0 mg per kg maximum limit, and they have written it 100 mg per kg, my lord. That is 25 times more than what is prescribed as per the regulations.
I'm grateful to my learned friend for pointing it out. I'll get instructions on that.
Counter affidavit on behalf of the Commissioner of Secretary, Government of Assam, Fishery Department, is filed wherein it is contended that wherein it is stated that some of the samples have been collected and the same has been sent to the Central Inlet Fisheries Research Institute, Northeast Region at Guwahati, as well as Central Institute of Fishery Technology of Cochin, Kerala. And the reports from the said institutes is awaited. Full stop. The concept of the petitioner has pointed out that in the affidavit filed on behalf of the Fisheries Department, they have wrongly mentioned the maximum limit of naturally occurring formal and dihen in freshwater fish and backfish alias marine fish. And the counsel for the Fisheries Department has submitted that he'll seek clarification from the concerned authorities regarding incorrect fact mentioned in the affidavit. Let's stop. Let's do this matter after 2 weeks. And then clarify.
Item 44.
Please, Your Lordship. Lordship, yeah, I need some time to file a reply to the affidavit filed by respondent number 4, Lordship.
What affidavit they have filed?
They have filed on seconds. So I need,
So they have taken action against the hearing officers.
Lordship, only the affidavit filed by respondent number, they say that only it's in progress. But nothing has been mentioned, Lordship.
They have already initiated the preliminary inquiry and then as per the result of that preliminary inquiry, then proceed further.
That is there, Lordship.
So what remains now in this petition?
Lordship, I need to file reply to the affidavit filed by respondent number 4.
The purpose is served, they have initiated the inquiry. Now, whatever the inquiry result, the report of the inquiry, they proceed in accordance with that. In fact, seriously, you are now, still you are pressing this petition.
Yes, Lordship, that is there, but
Was that where is for an independent input? Where is for an independent input? But ये तो कर
Then counsel for the petition has submitted that she needs some time to
Close it.
file.
no, Lordship, next year.
Counter to the reply filed on behalf of the respondent number 4. Stop.
Of them.
Item 45.
ये भी yes, yes. Stand the picture, my dear.
Is there, look at there.
My lord, this
The last reason,
yes, my lord.
we granted some time to,
My lord, some instances he needed to put
and
forward.
ultimately, if any person, an individual is, pasted a sticker on his car or anywhere, how the bar council can take any action against him?
We are helpless, my lord.
What is the authority of the bar council to take any action against?
We do not have, my lord. We absolutely we do not have. And we cannot issue stickers, my lord.
On 13/3/2024, the petitioner in person was granted
Right.
time to file affidavit
Support of.
in support of allegations leveled in the PIL petition. Today, the petitioner person is not present. In the interest of justice, please this matter after 2 weeks.
Deeply obliged.
Item 46.
Another bench, one of us.
Mr. Chaudhary, 46, I cannot take. I was the earlier councillor.
Okay, okay.
And some matter is pending in the Supreme.
Oh, yes, item 46 perhaps first.
Matter is pending in the Supreme Court.
No, my lord, that review has been filed, review was filed, review has been rejected. But there is another catch in this case, finally, a single judge of this honorable court has already recognized our right, where Lordship's obligation now appeared.
Okay.
Now, while implementing that, state has done a mistake. We are against that,
Again.
which the learned single judge could not appreciate. Learned single judge relying upon R.A. Bhatt's case, rejected
That
our
is the-
claim.
yes.
That is the case.
Item 47.
47. Lordship, in this case, I have received instruction to file our reply. Lordship may grant us 4 weeks time, Lordship.
Maybe it's for 7 foot. Thereafter, there will be a wait list. Now, the last candidate in the wait list and the petition got his vacancy, but he was 8 plus senior, so he got it. Depending on the government paper, okay, because the form of vacancy, we will now actually be wait list. Okay. So he will not be considered, he will not include the individual. You are not there in the first place. And he has not been able to show that this much number of vacancies. So that required an extension of the.
Okay, Mr. Swain, so put in evidence on behalf of the respondents and place some time to file counter to this. And it will be this conference, so. Thanks.
Item 48 and 49.
Lord, the present petitioners, they are all employees of the honorable court. Lord. They are in that E section, my lord.
Yes,
Now, our grievances regarding, my lord, disparity in pay.
yeah,
Now, in fact, from the point of view of the honorable high court, my lord, on the administrative side,
yes,
the matter has already been referred to the state government.
state government.
The government is of the, sorry, honorable Guwahati High Court has instituted a committee, my lord.
And
The
then.
committee having gone through all the pros and cons of the matter are of the view that no, it needs to be enhanced.
Yeah.
So now, my lord, government on one pretext or other, and they are saying no, it can't be done.
Maybe, my lord, I am appearing on behalf of the finance department in both these matters, my lord. The affidavit in opposition has already been filed. May I pray, my lord, lordship, may we please fix this matter for final hearing on any date, my lord. Today
we are here.
my lord,
The lunch.
my lord, with all humility, my lord, my learned colleague B. Gogoi, my lord, he is, my lord, doing this matter. Today, some person and
Once the High Court has recommended for that, what the
Yes.
authority of the, this, and
we will,
some the.
we will satisfy with all convincing materials before this honorable court. In the affidavit, my lord, we have negated the claim. How, my lord?
Normally, Mr. Once the High Court, referred you with the, some, pondering over the matter, then you are not, this is expected until and unless some, it's altogether, illegality is going on, happen to, otherwise not.
My lord, here our.
You should respect the High Court.
Yes, my lord, here, my lord, our primary defense would be, my lord, the expert committee, that is the pay commission, has not made any specific recommendation.
This, if the High Court is making that.
No, my lord, that will not always hold good, my lord. Yes, in an appropriate case, yes. But here in this case, my lord, Honorable High Court on the administrative side had constituted a committee, had gone into it. In the additional affidavit, have brought on record that.
Otherwise, we are going to, and we are not going to place it for final hearing. It is, we will decide it at admission stage only.
My lord, only for today, my lord, with all humility, my lord. Only for today.
The council appearing for the finance department, there is some time to prepare the matter. Time paid for is granted. List on when?
My lord, can it be in next week, my lord? Next week or the week thereafter, my lord? Subject to my lord's convenience.
Listed on 4th of June.
4th of June.
My lord, will it be inconvenient on 30th of May, my lord?
30th of May, I think we have already fixed some matters. 30th of May, that that matter is also there.
That's Sikkim matter. Oh.
That is.
My lord, instead of 4th May, lordship will have it on 3rd May, my lord. 4th May have some difficulty, my lord.
3rd June.
3rd June, sorry.
3rd June.
Yes.
3rd June. With this understanding that the matter would be disposed of at admission stage.
My lord. Deeply.
I'm so obliged.
Item 50.
My lord.
You oblige us by pursuing the state government to accept that.
My lord.
The recommendation.
My lord, for the last matter, item number 47, interim order may be continued, my lord.
47?
Interim order may continue.
Yes.
If the railway line is closed over the road and the road is blocked by the railway authority by digging pillar, which disrupted the road communication of the
You are
villagers.
praying for this construction of railway under bridge.
Yes, Lordship. And it was agreed.
But the Popar party was not made as a part. The Popar party was not made as a respondent, my lord.
Who is not made as a
But the Popar party, my lord, after
proper party?
yes, ma'am. After completion of my lord.
Railways is the railways
No, my lord,
party.
now it is look after by the open line department, my lord. So he has made my
Which
lord,
department?
open line department, my lord,
Open line department of
railway, my lord. Lamning
the
division.
railway is there.
Yes, sir. Now my lord, we are waiting for receipt of the payment from the my lord, PW department, government of
So
Assam.
principally you have taken decision to construct the IUB.
Yes, madam. But because we are waiting for receipt of
The
the.
issue is that, Lordship, that they are telling that state government should provide fund. And state government is telling that no, railway should provide fund. The issue is this. That is why they are not being constructed.
I am meeting the instruction flow. In fact, at one moment, railway said that they will construct 3 railway over under bridge, but subsequently they have issued a letter that 5 crore and 85 lakhs rupees in the year 2015. That amount has to be deposited and then they will construct. I need some time. Let me have the instruction for up to date position. What is that? What is there?
pay the amount or whatever it may be. You are supposed, at least the bridge is to be used by the citizens of the state. Pay this. What's wrong in that?
So it was 5 crore 85 in the year 2015. By now,
Now it's almost 10 crores.
maybe.
Pay then why you are getting
And
this?
this 5 crores is for the 5 or 3 REBS.
No. It is for 6. At that point of time, it is 6.
And I'm here for one only.
But in the meantime, Manoj, there is some progress is there, Manoj. In some other PILs already Lordship has taken care of, and the page 33, Lordship will find that some amount has already been given in respect of one REB. But let me have the instruction in respect of this REB, Manoj, what has happened.
And that REB has been constructed already.
What was this earlier petition?
Earlier PIL, according to the petitioner, it is in respect of railway under this different. There are
Different locations.
There are seven different already government has given the amount at page 33.
Concept of the. This writ petition is filed in public interest, raising a grievance that the respondents are not constructing a railway underbridge at the concerned location, resulting in great hardship to the residents of the concerned area. Full stop. Learned counsel appearing for the petitioner has also submitted that as a matter of fact, principally, it is decided by the railway authorities to construct, decided by the railway authorities that the RUB is necessary at the concerned location. However, the dispute is regarding the funding of, regarding providing finance for construction of the RUB. Full stop. Learned counsel for the state as well as the counsel for the railways place some time to complete their instructions in that regard. This matter after 2 weeks.
Look.
May I pay for a date?
डेट दे देना अब इतने दिन से नहीं बना है तो अब आप डेट मांग के try to get it done by yes.
Supplementary list, item 55.
This is for correction of the.
Correction of the
Cost title.
the cost title of the IA, my lord.
Phase 3 instead of having a time respondent instead of respondent number 1.
It's on main item. Makes sense. Yes, Miss Smith.
In the computer system, my lord, it was correctly mentioned, my lord, but only in the hard copy, my lord, that wrong has been committed, my lord.
What's the discrepancy?
Discrepancy, my lord, only the state of Assam, it had to be a respondent number 1, but typographically, well, there had been error, my lord. It has been stated as 2.
This one, sir. 2, it starts with 1, it became 2.
The application is filed by this IA is preferred on behalf of the applicant with the player to make minor corrections in the cost title of the writ appeal
IA, my lord.
of the IA number
1219.
1219/2024. The application is allowed. The minor corrections in the title of the IA number 1219/2024 are allowed. Amended cost title already filed, be taken on record. And what about this?
This IA, my lord, IA has been filed, my lord, since the appellant is going to be retired in the month of October 2024. So one representation is still pending, my lord, before the authority concerned for promotion, my lord.
They connected writ appeal and IA number. List the IA number 1219/2024 and the connected appeal in the next week.
Lord.
Obliged.
Okay.